The Georgia-Sri Lanka dual citizens' aspirations of contesting in the looming local government elections are now over. She placed her deposit to contest in the Galewala Pradeshiya Sabha in the Matale district under an independent group. With the window for submitting the nominations for the local government polls coming to a close at noon yesterday, the relevant district returning officer confirmed her nomination was rejected. However, the rejection was not over her dual citizenship. It was confirmed that certain shortcomings in her application brought about the rejection of her nomination. However, if the rejection wasn't over her dual citizenship, and if her application did not have the said shortcomings, then what would have been the situation? We put the question of dual citizens contesting polls at constitutional law expert, attorney at law Krishmal Vardnasurya.
With the 19th Amendment, we brought in a provision that if you are not a citizen of Sri Lanka, you could not contest an election. Then the 20th Amendment to the Constitution, after the Gotabaya Rajapaksa government came into place, repealed this provision. Thereafter, the 21st Amendment reintroduced this provision. And that is why, if you would recall, in contemporary history, the aforesaid individual and several others had to lose their parliamentary seats. So this has been in discussion now as the law stands in Sri Lanka in terms of the Constitution. For the general election, which also transforms itself to a presidential election, no person other than a complete citizen of Sri Lanka can contest such an election.
But the election concerned is neither a presidential nor a parliamentary election. Attorney at law Vardnasurya gave these thoughts specific to the local government polls and dual citizenship.
Firstly, a constitution being the supreme law of the land, you can't have any other laws operating, whether subsidiary or operating together with the constitution, that goes against that constitutional provision. Even if you go to interpretation, the constitution says that you have to be a citizen of Sri Lanka, and dual citizens or dual nationals cannot contest a general or a presidential election. That is the law. Now, when it comes to local authorities elections, as I said, obviously the general law must also prevail, but there is also a specific law. That is the Local Authorities Elections Ordinance. That at Section 9A very clearly says that if you are not a citizen of Sri Lanka, that is Section 9(1)A and subsection A. However, there is a provision if you are not a citizen of Sri Lanka, but that does not include members of the Commonwealth. As you know, Sri Lanka also belongs to the Commonwealth of Nations. So there is provision that prevails that if you are a member of the Commonwealth, that restriction doesn't apply. So Local Authorities Elections Ordinance, Section 9(1)A says that if you are not a citizen of Sri Lanka, you can't sit or be a member of a local authority. However, that does not apply to members of the Commonwealth. But even on this question, I would dare venture and say that even if that was so, one may call to question before the Constitutional Court, the Supreme Court, if the law of the land that prevails upon general and presidential elections are that such dual citizens cannot contest an election, even the provision of the Commonwealth in this local authorities election, that should not apply because the general law, the supreme law of the country, says that you can't.
Given Georgia is not in the Commonwealth, as per law she cannot contest the local government polls in any case. But since she placed the deposit, attorney at law Vardnasurya questioned under which provisions the Election Commission accepted her deposit. We also spoke to former chairman of the Election Commission, Mahinda Deshapriya, about the matter. He was very clear that the Commission itself had no power to launch an investigation into a potential candidate's citizenship. He insisted that an objection must be raised in court and seek disqualification from there on. Meanwhile, our expert on constitutional law concluded with these thoughts.
There is always an objection period in any election. So someone will have to raise his objection at the elections office within the given time frame that this should be rejected because this person is not qualified to contest. And that may lead to the nullification of the entire list. And of course, as lawyers, we know that when a returning officer rejects a particular list or a particular party list, then there is recourse for them either under the elections law to go for an appeal, or they can go to the Court of Appeal by way of writ application. And we have in the past, there have been several cases that we've argued when such election lists have been rejected and not accepted.